I would describe IP as it's the area of the law that touches everything and you don't even realize it. I really love IP because it is like the mysterious area of the law that floats across brands that we see and how they're protected, across inventions and designs that we use every day. If you were to just walk down the street, you would see a sign of a retail shop. That brand, as a brand, is a trademark. It can be protected as a trademark. It's used as a badge of origin.
So what's misunderstood generally about IP?
Pretty much everything.
How do you unlock the value of the intellectual property in your business? Anyway, what is intellectual property? I've invited Juan Perez, a prominent lawyer in the space, owner of Quest Legal, to have this discussion. If you think you've got any intellectual property in your business at all, have a listen to this. Let's talk IP for a minute.
As far as IP, what would you like to know about IP, I guess?
Well, it's an interesting thing now that everything's been digitised.
Yeah.
And it's moving way faster than it used to. It's like having a patent. Isn't it?
Yeah.
The IP is like an intellectual patent of some sort, isn't it? Or how would you describe it?
Okay. I would describe IP as everything you see around you. It's the area of the law that touches everything and you don't even realize it. It's almost, I really love IP because it is like the mysterious area of the law that floats across brands that we see and how they're protected, across inventions and designs that we use every day, across different, for example, even circuits and how we use circuits can be protected. So it's intellectual property are a series of different rights which protect services and products, and along with that, the inventiveness of them or the creativity around them as well. If I give you an example, if you were to just walk down the street, you would see a sign of a retail shop. And let's call it, I'm sure they wouldn't mind me calling out their name, TK Maxx, for example. My wife loves TK Maxx. She's so happy it's come to Perth. It's costing me a lot of money. And one's opening up close to us, so you know what? This could be a disaster. But she loves TK Maxx. Anyway, so that brand, as a brand, is a trademark. It can be protected as a trademark. It's used as a badge of origin, so people know that if it says TK Maxx, well, it relates to that shop and what they sell and what they aspire to. Everything attached to that brand can be protected as a trademark in Australia. So then you might go into the shop and there'll be terms and conditions of entry, and then there'll be advertisements within the shop and different types of signage. Well, there's copyright in that because they would have developed that themselves. So in that form, you've got copyright. And then in the products that they're selling as well, now that'll be owned by the individual manufacturers, but in the products, so you pick up this great new camera and you go, you know what, I'm going to buy this camera, but you look at it, it says patent over it. Well, there's some kind of inventiveness in that camera and that's being protected and you don't even realize you picked up this product and it's got its own brand, it's got copyright over the labeling, and there's a patent over it as well. And then you might pick up a great vase and go, wow, what a beautiful vase. I've never seen one like it. Well, that might have a design on it, so no one else can create a design of a vase like it. So IP's everywhere, and that's only one shop. You go to every shop and you're going to have that kind of experience. So IP are a series of different rights which protect either brand, which protect messaging, which protects inventions, which protects designs, which keeps information confidential. And as lawyers, we try and help our clients navigate this to understand what is the intellectual property they have in their own business and how can they make the most use of it, and how, as far as selling it, commercialising it, licensing it, and how do they protect it as well? And in Australia, as it is in most countries, there's two types of rights: those that can be registered centrally with the government, and those that can't be registered or don't need to be registered, and which, so long as you meet the minimum criteria, you get protection for them as well. So ones that can be registered are trademarks, designs, and patents. There's other types of rights, but they're the most ones that our clients use. Whereas ones that can't generally be registered, at least not in Australia, is copyright. Copyright subsists or is created if the creator of it meets the minimum criteria for copyright, which is that it can't be a substantial reproduction of someone's work, that they've created it substantially themselves. Then other rights like confidential information, you can protect your trade secrets through a confidentiality agreement, but there's no central register for that as well. So does that give you a bit of a sense?
Yeah, it does. And I've got a stack of questions now. One, and this is a tiny question.
Yeah.
If you produce some material, let's say it's original material, it's written,
Yeah.
to be protected under copyright, do you actually have to display that symbol?
No.
I didn't think so.
No.
But somebody said to me, this goes back months and months ago, they go, oh, no, you need to put the little copyright symbol and copyright 1998 or whatever it is.
Yeah. There's lots of these myths about what you need to do to protect copyright and that it's you can avoid copyright if you amend 20% of it. No, that's not the case. That's not how the law works. If you have a copyright issue and someone's breaching your copyright, the courts will do a side-by-side comparison, and they'll also look at, has the substance of this material being copied by this person as well. And so there is no rule as the 20% rule. And there is no rule around you have to put the C with a circle around it. The C with a circle around it is smart because at some point, whether you can make a claim for someone breaching your copyright, you'll have to evidence that you own that copyright. And how do you go about doing that? Well, you may have to show that the original drawings or the original words that you created, and it might be a file with a date stamp on it. You have to provide evidence that you created it, published it, used it. And a great way of creating that evidence is to put notices on your materials. So we have notices we prepare for clients, which we tailor for them, which are the C with a circle around it, saying copyright, the date it was created, who owns it, and if it's confidential, some wording around the confidentiality of that material. But you don't need a lawyer to do that. I mean, that's pretty standard stuff. So you don't have to have it, but it's a good thing to do just to have that evidence trail.
So what's misunderstood generally about IP?
Pretty much everything.
Even the word IP is misunderstood.
Yeah, what is IP? Well, it stands for intellectual property, right? And it's intellectual because they're rights which are then they're rights which are not just like, for example, getting a right over land, like it's tangible. It's intangible rights, and that's the intellectual nature of these rights. And so I think that's a good starting point. What does IP even stand for, or intellectual property? And there's misconceptions that trademarks, for example, I've had clients say trademarks aren't useful. Well, any intellectual property right is only as useful as the owner's ability and desire to actually take action to enforce it. So I don't agree with that concept, that it's not useful, that trademarks are a waste of money, because we're enforcing them regularly.
Really?
Yes.
Can you give me an example?
Well, I give this example a number of times when I've been out at, because I present on IP regularly in different forums, and one of our clients actually allowed us to use this as an example. They've even allowed us to use their name, which was really cool of them to do that. And so years ago we acted for a medical practice in Forest Lakes, and they called themselves Forest Lakes Medical, and been around for many years. They've been trading for over 30 years. And so some years ago we had a chat. The owner and I have known him for many years, lovely fellow, and I said to him, look, you really should get your trademarks done. And he agreed and took my advice, and we did his name and logo and protected Forest Lakes Medical. And then some years later, up the road, we're talking 2 kilometres away, in the shopping centre, someone opened up Forest Lake Surgery. Now, what then ensued was just a heap of confusion around patients going to the wrong clinics, and as bad as hospitals sending reports to the wrong clinics, and obviously our client was very alarmed by this. So we issued a cease and desist and asserted our rights under the trademark. Now, the fact is that without the trademark, we could have still asserted our rights. There are still common law rights to be able to say that you have been using the name for some time and that you own it. But it's a harder process to protect that and to assert that. Much easier, and gives you this full protection under the Trademarks Act if you're able to have the trademark. So we wrote a cease and desist, and the original reaction I got actually was one of, no, we don't have to stop using it. We're just using it. It's the name of the shopping centre. No, you can't use it. Anyway, we can use it. So long story short, after a period of back and forth, and they engaged a lawyer, and then we talked to their lawyer, and we were able to assert our position strongly. They then changed their name, and everything was agreed, and they were able to go their separate ways. And the confusion ended. Without those trademarks, it could have been quite a lengthy and difficult process. So, and to this day, we keep renewing those trademarks for them, so they still have full protection over those brands as well. Yeah.
Wow.
Does that give a good example?
Yeah. That's interesting. There's something I need to talk to you about, as a matter of fact.
Sure.
So that's on trademarks. What else is misunderstood in IP and in protection?
Yeah. So there's sometimes clients will come to us and they'll say, I want to get an invention patented. Now, we work with patent attorneys are quite specialised in their particular fields of expertise, and so we tend to work with different patent attorneys that specialise in those areas because it's important they understand that particular area, and it might be in chemistry or it might be in mechanical or software or other areas. So we work with regarded specialists in those fields. But we work with our clients when they say to us they want something patented to make sure that is it even something they can explore as being patentable, because sometimes they'll come to us with an idea that is just really not inventive. There's a certain minimum criteria. There's got to be a level of innovation, inventiveness to the idea. It's got to be novel. It can't be something that's just a reproduction of what someone else has done. They just didn't patent it.
Yep.
And the other thing that can happen is that they've sometimes think, well, I can just patent it, even though they've already put it on social media and advertised it on their website that they've created this, and in some cases even started selling it. It's got to be patented before they commercialise it and before there's any publication of it as well.
Is that a thing?
Yeah, there's a grace period that IP Australia will provide, which is 12 months. But if you've been out there just talking about it to every person under the sun or publishing it, then you lose your right to be able to patent it. So you've got to keep it confidential. And so clients that come to us, that's the first thing we ask is, well, tell us what you've been doing, who you've been talking to about it, have they signed confidentiality agreements, and sometimes we, to our clients' credit, some of them are savvy, right? And in that sense, AI is actually being helpful because some clients are actually coming to us having got some good information through AI or other means where they go, oh yeah, I knew I couldn't disclose, but others have just gone and disclosed, and you may have a problem here as well. So that's another example.
So talk to me about how useful it is, because I still talk to a lot of people and I see things on their balance sheet. I go into their business, and they've got great ideas.
Yeah,
that's interesting. I haven't heard of anybody doing this. And they go, no one we know of is doing it.
Yeah, you're talking about an idea.
Some of them are. Some of them are processes.
Yeah,
some of them have actually invented a product.
Yes,
and I don't know. I don't hear about people lodging patents as often now. Like it's not a regular dialogue as it might have been 10 years ago.
Yeah, there's a strategy with any invention or creative process that you've created that you put into place. Firstly, if it's a process that you've developed which is unique, they can be very difficult to patent as well, because there's a question around the novelty or inventiveness of it when it's already a process that's in place and you're just trying to automate it. But it's not impossible, but there's a hurdle there to overcome. But the other thing is strategically, you've got to ask yourself, well, what's the secret sauce here? What's the secret ingredient here? Is it an algorithm you've created, or what is it that you keep confidential and no one can use? And so some companies take the position of, you know what, we will just guard the secret, the algorithm, or in KFC's case, for example, the secret herbs and spices, and they will take the position of let's just keep it under a safe vault and anyone that touches it under confidentiality. And the reason that can be a good strategy is because it means that there's no end date to that, whereas a patent has an end date. A patent has a life of 20 years and in some cases, well, for pharmaceuticals, can be extended to 25 years. But after that, it becomes open.
Yeah, so everyone can see it eventually.
Yeah. And that's why you get generic drugs, right? Because those patents have expired, and then pharmaceuticals can just go and create their own generic versions of those drugs. So for that reason, if you are going to patent, then you've got to do it knowing that it discloses what you are doing, knowing that it has a shelf life of protection, and you have to make it rain during that period of protection, but also be prepared and willing to enforce it. Now, enforcing isn't cheap. You know, we're talking court action and potentially court action, and it can be time-consuming and expensive. So some of our clients take the strategic view of, I'm not going down that path, I'm just going to keep it all confidential. There's a risk with that, which is there's leakages and you don't protect yourself fully, and or it's not that inventive and someone just looks at what you're doing and goes, I'm going to do something, but, you know, reverse engineer it. So there's always risks with each strategy. But you're right. I would say that at least with our client base, I can't talk about everyone else's client base, but at least with our client base, the propensity for jumping to a patent has reduced over the last probably 10 years, I would say. And they look at other forms of IP of protecting what they're doing as well. The thing, here's a strategy though, as an IP lawyer, is we try and place our clients in as many clubs, if you want to call them, of IP as possible. The more areas of IP you can be protected under, then the more options you have if someone infringes your intellectual property. So clients will come to us and they may have 3 or 4 areas of IP where they can be protected, where some of the materials are copyright, they can protect their brand, they can keep their secrets confidential. So with each client, we'll sit down, understand their business, understand their products and services, where are they going with these, Is it just in Australia or internationally? And all of that we work through to then determine, okay, what's the best strategy for you? And I love that part of the law. For me, if it's just sitting behind a desk and saying the Patents Act says this or the Trademarks Act says that, I mean, it's just really boring.
And who cares, right?
And clients really don't care about that.
Yeah.
What they want to know, clients want to know, well, they want to understand what is intellectual property and why it's relevant to them. They want to know what value it's going to add to their business.
So that to me in business is the critical element.
Yes.
Because it's easy to say, oh, I'll trademark my brand, but the value question.
Yes.
That's where the money is.
Exactly. And this is what gets me so excited about IP. A company that understands their IP, that protects it properly, and then commercializes it well, the multiplier effect of that is significant. You think about a company like Apple, right, with billions of dollars. And if you really stripped back all the assets, right, the tangibles, by far what would be left as value would be the intangibles, which is the inventions and all the intellectual property that they've created over time, which they're licensing, and all the licensing agreements and the contracts that you and I sign every day for their products. All of that's intellectual property. And so a good business that really understands that will be able to generate significant profits from it. But more importantly, on exiting, if they were ever to sell their business, can get a much bigger multiplier effect, because it means that they have an asset that can continuously be commercialized, that can generate recurring income, and that's music to the ears of any investor looking to either take a stake or buy a business as well.
Definitely.
Yeah. So that's what excites me about intellectual property, the value it can really create.
So a conversation with you, if I could frame it this way and tell me if I'm wrong, it sounds to me as if a conversation with you isn't a conversation about IP law per se. It's a conversation about how can you unlock the monetary value of the IP that's in your business, whether you know it or not.
Yes.
It's a pathway to making more money, potentially.
Yeah. When you summarize it, it's not much more complicated than that. And I think we surprise some clients sometimes because they come to us to say, oh, I'm thinking of this and I've got this idea and I'm doing that. And then we talk more broadly than just the law. The law gives the framework, the law gives the foundation, but the strategy around then what you do and how you're going to commercialize it is the bit that's fun. And then when they know what they're doing there is, well, how do we protect you along the way with that? So are you going to start talking to a manufacturer, say in China? Well, what are the dangers of that? And how do you protect yourself knowing it's China? And then you're going to have distribution agreements around the world. Well, what happens if you appoint a distributor and then they go rogue on you? What's the contract going to say on that? And if you're going to sell overseas and your brand's going to be sold to, say, the US or EU, well, how do you know that that's not going to infringe someone else's intellectual property? So as you're going through the strategy and the approach, then the law touches each of those spots, right?
Yeah.
And that's the fun bit to me, because we join the dots in all of those areas as well.
Can I go back to the value bit for a second? Is there a point at which a client comes to see you and you think, or you say to the client, we're not quite at that point yet, or it's not economically feasible for you to go down these paths? The idea is great, but is there a minimum size of enterprise that you would say this is worthwhile?
It's it's not really our call to tell them that. I mean, they've got to develop their business case, figure out the market. There's a lot more to it when you commercialize IP. Going back to your original question, what's a misconception? A big misconception in IP and for our clients is that I've got this great invention, it's going to make me a lot of money. No. There's lots of great inventions out there that make no money at all. And great ideas that just never get commercialized. And that is because to understand the commercialization process, just having a great idea has to then become reality. And so the reason I mention all this is because, and it was one of the first partners I ever worked for when I worked in Norton Rose. Back then it was called Deacons, who said to me, never underestimate how long a journey an inventor has to get to the point where they've made a lot of money out of this. You have to be able to define your market. You have to be able to build a prototype of it. You have to be able to then make sure that it's hitting that target market. You have to work out in each jurisdiction what it is you need to do. Manufacturing as well is a big component of it. There's a lot of cost that comes with all of that. What's your strategy? Is it going to be to manufacture it yourself and set up your own retail shops and all of that? Or is it going to be to sell the invention and the idea to a big retailer out there because they don't have that product or that idea? All of that takes time and money to get to that point. So back to the value, we don't tell them this is not valuable. It could be. We just tell them, just educate on the process and what they will need to do to get to that point of commercializing and to get to that point of really extracting that value and say, this is how much it's going to cost from a legal perspective, for patents, trademarks, all of that. And then tell them along the way, as they're going along that journey, okay, you need this agreement or this is what it'll cost and so forth. They can then get a feel for the overriding cost of doing this. And if the idea is small, at least they will have a sense that it's going to cost a bit to get to that stage, right? And they can make that commercial decision of whether it's worth it or the opportunity is big enough to warrant that. And we just guide them along the way with that. But I would never tell a client that there isn't just enough here. What I do tell clients sometimes, especially if they come to me with an idea right at the start, and let's say it's let's call it a new clothing brand. And the name's really cool, interesting, and they've got a couple of logos and they've got a main name to it. So when they come to me and they say, well, we're just doing this on the shoestring, we've got to get it out there and see how it goes. And they say, look, the maximum we've got is, say, 5,000 for the whole thing. Try and see how we go. All right, well, then you really got to be careful, because I don't want you spending all your money on building walls of protection and then not have enough money for marketing this. So let's tailor how much you're actually going to protect. It might be that instead of protecting every single one of your logos, we've got to choose the main one you're going to try and make money from, and we'll just do that. And that's going to cost you less and won't give you the full protection, but at least will let you have a good level of protection to get started. And then you'll still have budget to be able to get it out there.
Go to market and actually sell some stuff.
At least test the market, and get the ball rolling. So I do see, I do have to understand where clients are in that journey, understand financially how far they're willing to go with taking this product to market, and then being real with them as to not just our cost, but what will be the cost generally of them getting this to market as well. Yeah. Does that answer your question?
Yeah. It's because it's such it's nebulous, isn't it?
Yeah. Yes.
And I think a lot of people don't know they don't understand it necessarily. They don't understand the value it could add or the protections it gives you.
Yeah.
And I don't know that people know where to start and who to talk to.
No, they don't. And I guess this is where I find what we do fun and sometimes exciting, is that we're not just IP lawyers, we're commercial lawyers as well. And that's important and become increasingly important because you need to understand the business basis and the underlying triggers for that business and that client, their goals, their aspirations, and the broad business context of what they're trying to achieve in order to then be able to properly protect it and advise. And so it is nebulous and every client will be different. So our job as IP and commercial lawyers is to ask those questions and be able to understand more what is that client's motivation, where they're going to take this. Is it just Australia or is it overseas? What structures have you got in place? Like, are you going to be entering into some pretty large contracts for supplying of a product and you're doing it as a sole trader? Like, seriously, do you know that if this product fails and you get sued, it's your own home that's at risk? So all those discussions have to happen at the start so they understand the risks. But I enjoy the fact that, as you said, it is a bit nebulous. Instead of nebulous, I would just say it's nuanced to every client. Yep. And that's the interesting bit, that we hear every client's story and it becomes a really interesting story each time.
So what would you advise people who are listening to the podcast and thinking, I never thought of IP before.
Yeah.
I wonder if it's relevant for me. I wonder if there's value in my business if I went down that path.
I would say you might be surprised to find that there's more IP in your business than you thought. And secondly, you might be surprised it's not necessarily as big or expensive a process as you might think. Most businesses, established businesses, they may not have an inventive element to what they do. They may not have created a great new product that's hitting the market by storm. Most businesses are, if they're a service business, are providing a pretty standard service. They just have their own twist on it to differentiate themselves from others. Well, even that kind of business will have a unique value proposition and brand, which can be protected as a trademark. They'll be producing works for their clients, which can be potentially used time and time again with other clients. Well, they're creating IP as they're doing that. So they need to make sure they retain ownership of that. So we look at that. We look at the copyright they're creating. They may be entering into discussions of a confidential nature. Well, is that protected? And is it very clear between those parties that it's confidential in nature? They may be engaging contractors to help them with this work, not knowing that that contractor actually owns the IP that they're creating for them. So how do we assign that IP across as well? So my message to them would be that for most clients, it's actually not as big a process as they might think, because for most clients, it's a combination of trademarks, copyright, and confidentiality. For those that are very much involved in creating products and new inventions and so forth, then you add to that patents, potentially designs. We've even had clients that are doing varietals of plants, so you're talking plant breeder rights. Pretty cool. These areas become
and
quite
wouldn't
interesting.
Naturally think of it.
Yeah.
I've seen that.
Yeah, that's right. Grafting of different plants together and creating new plant varieties is just fascinating to me. So I would say it's not as hard as you might think. And where we always start is let's just have a chat. We don't charge for that chat. And the reason we don't charge for that chat is because if we did, then clients feel like, okay, come on, get me out. We want to actually really understand and hear where they're at, where they're coming from, their motivations. And then we can work out, well, can we even help you? In some cases, we can't. They don't need our help. In most cases, they do, and then we give them a quote and we get on with it.
Easy.
Yeah. And we enjoy that.
We would love to get you back on AI and the law.
Yes.
because that's developing at a rapid rate of knots.
Yes.
And again, that's another massive area.
Yeah.
I think it doesn't have a massive framework around it yet.
No. So when I come back, I'll go into it in a bit more detail, but to give you a sneak peek of it, and I've presented a number of times in different forums on AI in different industries as well. So intellectual property, which we just covered, is the base of AI, the copyright that's created and so forth. And that's a whole other topic. Is it actually copyright or not? So that's a teaser for you. The framework in Australia is that there is no AI law. There are other countries, and EU is an example, which has an AI law. But in Australia, it's still very much that the different laws that already are in Australia are applied to that AI environment or tool. And it doesn't always work. It doesn't always fill the gaps, the current legislation. So when we meet, I'll talk a bit more about, well, what is the law around AI? And what are the issues that we are seeing as far as how AI is being implemented by businesses? And an example, just to give you a sneak peek as well, is where, and I should just say at the start that I'm a big proponent of AI. Like, I think it's just an incredible tool and should be used, but it just needs to be used very carefully. And I'm seeing more and more examples of our clients and third parties using AI in a way that's potentially already breaching law, and that could have serious implications for that business. So it must be used very carefully. One example is I'm seeing more and more businesses where they start recording a Teams meeting or a Google meeting, whatever it might be, and they start recording it without getting permissions.
Yep.
Very common. Well, that's actually a breach of legislation to do that. And each state has legislation around that. And there's also Telecommunications Act, which is national, which relates to recording of telephone conversations and other forms of communications. The Surveillance Acts, there's one in each state, and the Telecommunications Act, if they're breached, can be criminal implications of that. So we're seeing more and more of that where suddenly you're in a meeting and it gets recorded and no one's even asked permission of those attending. Can I record this? And secondly, probably even worse, is that the video might get disseminated to everyone that was copied in and invited, even if they didn't attend. And sometimes we've seen examples of people actually having little side conversations at the end of the meeting, which then gets given to everyone. We've even seen the risk of privilege being lost because communications and meetings we have with our clients, that's got to stay between us. But if the client then forwards that video to someone else, you will lose that privilege.
Of course, yeah.
So all of these things are just happening. So when we meet, I'll give you some
we'll lock it in. That'd be great. Yeah,
as well.
That'd be fantastic.
I hope that helps.
It will.
Great. Thank you.
So where do people find you?
Well, you can just go onto our website, questlegal.com.au. They can email us at info@questlegal.com.au. And we have a team in Perth and Sydney. The practice, I'm originally from South America, and then we moved to in mid-70s. Actually, we moved to Melbourne, lived in Melbourne a number of years, then to Perth. Perth is where I was educated. A good chunk of my career though was in Sydney, but my family's all in Perth, and then so I lived in Sydney for 15 years. I love both Perth and Sydney, Melbourne as well for that matter. But we came back for family reasons, with some of our family not so well. Anyway, and it was a good time to come back because we got to spend some good quality time with those family members. But I still have family. My daughter's in the practice. She lives in Sydney still. And so we kept the Sydney practice growing and going, and it's going really well in Sydney. And then when I moved back to Perth about 6 years ago, we set up the Perth office. So our clients are across the country, but a good chunk of our client base are either in Perth or Sydney. So they can, if they need to see someone face to face, we can meet with them as well.
Fantastic.
If needed, yeah.
What do you like about Perth so much?
Well, apart from all our family, my wife's family and my family are here. It's just so different. So when I was in Sydney, I love the hustle and bustle of it. It's very cosmopolitan. Things are open 24/7. You walk down the street, there's people everywhere. So there's kind of safety in numbers in Sydney in some ways, right? Because as you're walking around, there's always going to be someone. And yes, like any other city, there's crime, but there's a feeling of safety in that. Perth's quieter, and in some ways, you don't get that. But Perth has grown so much, and you know, when I left Perth to go to Sydney was over 20 years ago, and coming back, the city is just transformed, and you see it everywhere, and in some ways it's going through quite a bit of growing pains as a result. You see it in the traffic and all of what we observe, and in the public transport. But as a lot of infrastructure is being developed and evolving, just the vibrancy of the city, we saw it, you know, going into around Rain Square and those areas on a Friday night. It used to be very, very dead, and now it's just full of life. And that's quite exciting and fun. So you always get the best of both worlds now, because it's quiet where you live, it's quieter in those pockets. But if you want some of that hustle and bustle, you can see it in Perth. It's not quite yet as it is in Sydney, but I'm okay with that.
Yeah. Can always go to Sydney if you want that, right?
And I do, because with our office there and my daughter there, then I'm going to go and visit when I can. So I do go a few times a year as well. So, but I love Perth and I love Sydney. So I guess I get the best of both worlds. Yeah.
We live in a great country. I reckon we're all super privileged.
We are. And look, I travelled enough to South America and to Colombia, where I was born. And Colombia's a beautiful country. Oh my goodness. It's just, the people are incredible. The countryside is green and luscious, and it's really evolved. But through South America, you still see a lot of poverty, and you still see that it's not as developed as it is for us here in Australia. And so I don't take for granted how lucky we are here in our country. I think a lot of people do take it for granted. I hear a lot of complaining, but at the heart of it, the liberties we have here and the opportunities we have here, I just don't see anywhere else in the world. We really
me
are
neither.
blessed.
I know I travel around a bit, and I still come back, and I'm amazed at the opportunity we have here and the freedom.
Yeah, so grateful. And that's something we've got to protect and preserve, definitely. So.
Yeah. Thanks for taking the time.
No, thank you. I've enjoyed it. It's been good to catch up.
Thanks, Juan.
Thank you.